And I am Stephanie Galbraith, Community Development Specialist for the Cuyahoga County Board of Developmental Disabilities. I'd like to welcome you to the Planting Seeds of Knowledge webinar. This is our last webinar of 2022. The topic this month is guardianship. And with us, we have Richard Cirillo, our Chief Clinical Officer, and Sarah Kamek, our General Counsel, will join us shortly. So I want to tell you a little bit about some of our plans for next year before we begin. We are going to create a video library on our website for hopefully your easy access. So the library will contain webinars created by our organization on topics important to you. And we hope that you'll give us some feedback on topics that interest you and how we might design this video library. So in the chat and as well on the slide is a link to a SurveyMonkey survey. And if you have some time in the next few days to fill it out and give us your feedback, we would really love that. So we can design something that meets your needs. A little bit about the presentation tonight. So only the presenters are visible. Your name is displayed as a participant, however. And the presentation portions of this webinar will be recorded and made available on our website. So after Rick and Sarah talk, there'll be plenty of time to answer your questions. You can drop those questions in the chat or you can use the raise hand feature. We do value your feedback. So if you did register for this webinar, you will receive a follow-up email from us, and we will include a PDF copy of the presentation, a link to the recording, and then there'll also be a short survey about just the program and what you thought about it. And you know what, we'll also include that other webinar survey for next year's planning. And again, before we're going to go ahead and start recording now. So Mike, if you want to go ahead and press the record button for us.
It's recording.
Okay, wonderful. Thank you. So I'd like to talk to you a little bit before Rick and Sarah begin about our volunteer guardian program. At this time, we have 31 volunteers that are matched with one or more individuals who did not have anyone to look out for them or to help them make decisions. So these volunteers stepped up and have been matched with these folks to help them with their decision making throughout their lives. So I'd like to just show you a quick video we developed this year about the Volunteer Guardian program and what we have available here at the board. So let me begin, and please, Rick or Mike, let me know if you cannot hear or see this video, okay?
And hear it.
Thanks.
No sound here, Stephanie.
What was that, Rick?
There's no sound. I'm not getting any sound.
Okay.
Yeah, I'm not either right now.
Okay, well, let me stop real quick. Oops. Let's go back. And let's see if I can, I'm glad you said something. So let's look at my video settings. Audio. Volume up. Did you guys hear that?
No,
Okay. Can you hear it now?
no.
Okay, that's interesting. That's the first time that's happened.
I want
and-
to I want to remake you the host real quick.
Okay.
to
Oh,
see if
maybe that's what. Okay, should I try it again?
Yeah, if you could.
How about now?
Yeah.
Hmm.
Have you tried that setting wheel on YouTube to the lower right?
I don't think there's anything I can do
Yeah.
there.
I don't either. Hmm.
Huh, oops. Well, I'm not sure what else to do to make the volume. I've checked the video settings. Video settings, audio. Maybe if I unplug my headset, I think that might be.
Worth a try.
Yeah, you can try. I was looking at the slideshow that you sent me to. I was going to fire it up real quick, and I don't have the option. I don't have this slide. I was going to try it
Yeah,
here.
so let me try this one more time and then we'll just move on for everyone, okay? So thanks, everyone, for your patience. Any luck?
It's nice to have
Yeah.
someone on your side
There
you
it
go.
goes.
when you have to make big decisions. You could be that someone for a person
Good.
with developmental disabilities. Be a volunteer guardian. All it takes is a few hours a month, a willingness to get to know someone, and an interest in helping them reach their goals. Volunteer guardians act in the best interest of the person and serve as an advocate and substitute decision maker in the care and management of a person's medical and personal affairs. Volunteer guardian is an official title, legal by the support of the local probate court. Volunteer guardians are supported every step of the way. Cuyahoga DD's General Counsel guides volunteer guardians through the legal process, formal appointment, and any time there are questions. Volunteer guardians are part of a team of professionals and direct care providers serve as partners to ensure the person reaches his or her goals. Volunteer guardians are guardians of the person. They make decisions about medical care, like giving approval for medical treatment, or where the person will live to ensure that they have suitable living conditions. Guardians consider a person's wishes, as well as his or her physical needs and financial circumstances. Volunteer guardians are at least 21 years old. Complete a volunteer application process, which includes providing references and attending an orientation and background checks. Volunteer guardians also complete training offered by the Supreme Court of Ohio. This training is available in person and online. Volunteer guardians meet in person at least 6 times per year. Make phone or digital contact with care providers to discuss the person's well-being during the months you are unable to make a visit. Volunteer guardians complete and maintain records and annual reports concerning living arrangements, as well as medical, educational, or vocational services they have received. Annual training and continuing education is encouraged and may be required. Some of our volunteers share why they volunteer.
I love being a part of someone's life and team. As a guardian, it's an honor to help another person live a safe, healthy, fulfilling life.
It is so important for everyone to have an advocate to help them make important life decisions. All it takes to be a guardian is the commitment to want to help and the willingness to be there for someone.
Volunteers are essential to communities. You could be that someone for a person with developmental disabilities. Be a volunteer guardian. Learn more by contacting the Community Development Department at 216-736-4518. Our mission is to support and empower people with developmental disabilities to live, learn, work, and play in the community.
All right. There we go. So I will let Rick and Sarah, you can take it away.
Thank you. Thank you for being here. And my name is Rick Cirillo, and as Stephanie said, I am a clinical psychologist, and at the board, I serve as the chief clinical officer. And we're here with Sarah Kamek, our general counsel. And Sarah, I think I'll turn it over to you, at least for this very first slide.
Sure. Sure. Thanks, Rick. As Rick said, I'm Sarah Kamek. I'm the general counsel for the Board of Developmental Disabilities. I do a lot of work with individuals that we work with and their family members, and in some cases, volunteer guardians in connection with guardianship. And I'm always available for questions and to help assist with the process. I understand it can be kind of intimidating because you have to do it through the court, but we're certainly here to help answer questions that people have. So initially, we just wanted to kind of talk about what is guardianship in general. Guardianship is a legal relationship that gets established through the probate court, where an individual has the authority and duty. So that's an important piece of it, that it's not just the authority, they have a duty to care for another person's person or property. That person is typically referred to as a ward, that person's typically referred to as a ward. You might think of when people are minors, their parents serve as their guardians to make decisions for them. And sometimes once somebody becomes an adult, that parental guardianship automatically kind of terminates when somebody turns 18. But then there is this ability based on somebody's disability or incapacity to seek guardianship of them going forward if it's determined that there's a need for that. An adult can be deemed incompetent if they are so mentally impaired as a result of a mental or physical illness or disability or an intellectual disability, or as a result of chronic substance abuse that they're incapable of taking proper care of themselves, their property, or their family. So basically, there has to be a finding before the court will award guardianship of an adult that that person is incompetent to take care of themselves for one reason or another. If you want to go to the next slide, Steph. Okay, so common reasons to seek guardianship. I think Rick was maybe going to go through some of these.
Sure. So there's any number of reasons really why people will seek guardianship. And I think probably the most common denominator is that there's some concern about the person has some kind of a need and that need is not being met. And typically it's a serious need, and it's one that the person is not able to get that need met on their own. And people determine that in some cases, at least, a guardian would be able to change that situation for the better. So for example, there might be an inability for a person who is seeking medical care to be able to give informed consent, and the treating physician or healthcare provider may decide that I cannot move forward and provide the care that I otherwise would, because the person is simply not able to show informed consent. And so that is certainly one reason that sometimes people will seek guardianship, and it's often a very good reason. Although it's surprising how often, really, I think a lot of times healthcare providers do try very hard to not have to go down that path. But it also will relate to some extent to just the nature of the procedure. So I think as risk is greater, then typically I think in practice the bar seems to be a little bit higher in terms of what the healthcare provider will want to see. So many cases, what we have really is an inability of the person to really comprehend or to appreciate what's happening in order to understand the information adequately, to make rational decisions. And in the absence of those abilities, then we bump into, again, these oftentimes significant threats to safety or just basic well-being. And of course, we're a developmental disability board, and you know, the folks we see, these are typically resulting from problems with an intellectual disability, or it could be an autism spectrum disorder, or some other kind of neurodevelopmental condition that we commonly see. It's also quite common that with people we work with that there can be co-occurring mental illness. In fact, people who have a developmental disability are statistically about twice as likely as the general population to also have some kind of a co-occurring mental illness. And mental illness certainly, especially when it's poorly controlled, can also weigh into this. It can contribute to difficulties with the person being able to comprehend or appreciate or make rational decisions in their own best interest. We also find, I think increasingly at the board at least, that individuals who have had particularly unfortunate backgrounds, trauma-based backgrounds, where maybe they've experienced just different kinds of traumatic events that can oftentimes have a rather pervasive impact on the person's ability to control their own emotions, to control impulses, to trust others. It can be hard to know who to trust. And so in some of the cases that we work with here at the board, certainly we have people with very significant trauma histories, and it can result in them really struggling to make the kinds of decisions that they need to make in order to just to be okay, to preserve their own well-being. Next slide, please. So here at the board, we very frequently get involved in assisting folks who may need a guardian. We actually provide the expert evaluations, as they're called, by the probate court, that serve as part of the requirement for a person to receive a guardian. So there's a couple versions of that report, and these are all based on the court's own requirements. So there's what we call an initial guardianship evaluation. And so this is when, as the name would suggest, this is when a person doesn't have a guardian, and there's a belief that the person may benefit or really needs a guardian. And so there's a court form that we do, and we do this initial evaluation for guardianship. Those are required by the court to be completed by a physician or a licensed psychologist. And so in many cases, a family might turn to their treating physician, or maybe they have a psychologist in the community that's been working with them, and that person will hopefully be able to complete that evaluation for them. In other cases, a parent or a concerned other may approach the support administrator at the board, and then the support administrator can talk to us in our behavioral health support department. And we do have psychologists, and we will complete those initial guardianship evaluations when requested. We actually do quite a bit of them. In fact, I was looking at some of the numbers last year, 21, we did over 150 of the initial guardianships. And then we did really quite a few more than what are called guardianship reports. The guardianship report is kind of a variant on that. And what this is that a person has already had a guardian that's been assigned, and the court requires that those are reviewed at certain intervals. And for people who have what's known as an APSI guardian, APSI being an organization that can provide guardians, and under some circumstances, those guardianships have to be reviewed annually. For other folks, for parents and so on, it's voluntary guardians, it is every 2 years. And so in the case of the guardianship reports, they're less restrictive. Those can be done by a medical doctor or psychologist, but can also be done by what's typically referred to as the team. So someone on the individual's team at the board can also fill out one of those reports, and that can meet the requirements of the court. Although I think in practice here at Cuyahoga DD, they end up coming to behavioral health, and we review those. So to get our assistance, again, these are requested through the support administrator. So a parent, for example, may approach the support administrator and say, I would like to become the guardian of my child who's now become legally an adult. In other cases, the team, the overall team that's assisting the person becomes aware of a need, and there might be concerns again about safety, basic well-being, significant concerns. None of this is ever done casually. And in those cases, we actually have a process where we have a committee actually that will review requests coming from the team in terms of, is this something that we should try and pursue and see if a guardian is available to approach the court and see if it's appropriate. So that's sort of our general process that we go through at the board. And then Stephanie, if you could just move the slide. These evaluations that we do at the board, there's no cost for those. We do those just as part of our regular duties. And that's true for both the initial guardianship as well as the annual guardianship reports. Of course, if the person that's the subject of the evaluation does have to be eligible for our services. And so, when we're doing these things, we take them very seriously. It's quite a step to deem someone to be not competent and to take away their ability to just manage their own affairs. And so typically, especially with the individual guardianship evaluations, what we will do is we'll interview the individual, assuming that they're willing to be interviewed. And in most cases, the vast majority of cases, we are able to do that directly. We will review a person's records, different kinds of care they've received in years past that are relevant to this process. We'll certainly talk to collateral sources of information. So if there's a good historian in the person's world, whether it's a parent or a brother or whomever, we will talk to other folks to see what we can learn. Under some circumstances, if there's really a very acute need, an expedited evaluation can be requested, and we can do whatever we can to try and get it done as soon as possible. We very much try and work with the team and such so that a person's needs are being met. And typically, if there's no big hurry, it might be from the time we receive the referral, maybe typically about 3 weeks or so. But there's been times when we've been asked to do them and we've gotten them done in just a couple of days, if there's a really truly acute need and if the person's available. So the content of what we look at is very much guided by the court's form itself. And the way these then culminate is we go through the process and then we make a recommendation that guardianship be established or continued or denied or terminated. That's sort of the end result of our part. Next slide, please. And some of the content, just so you have an idea of what's in there. The court wants us to speak to things such as the kinds of medications that the person's prescribed, any kind of course of mental impairment, developmental disabilities, substance abuse, dementia. Oftentimes for our population, people that we work with, test scores become applicable. This is particularly when the question is around intellectual disability. Intellectual disability is a diagnosis. It's somewhat unique in that it actually requires standardized test scores to even make that diagnosis. So they look for those scores, particularly when we're talking about intellectual disability. We make observations about the person's mental status, what we see in front of us as we interact with the person, any kind of physical impairments or special characteristics. And then we form opinions about whether or not the person is able to complete activities of daily living and make decisions about medical care and living arrangements and so on. We're asked to weigh in about, are they able to manage finances and property, and is there any indication at all that the person's being exploited or neglected or abused? And also there's a question that's asked about, do we consider the condition that we find the person to be in, is this a stable condition? Is this something that's unlikely to change over time? Or is it something that maybe is likely to be reversed in the future? Because of course that will then speak to some extent to what might happen in the future. And so we also provide an opinion on that. Next slide, please. So at this point, I would like to turn it back over to Sarah.
Thanks, Rick. So there's a couple different types of guardianship that you can file for with the probate court. Specifically, you can file for guardianship of the person, which is typically just guardianship of the individual and decisions about their personal needs and meeting their personal needs. Guardianship of the estate is a little bit different. That is actually a guardianship over somebody's assets and their financial decision-making. Or you can be granted guardianship over both. Typically, guardianship of the estate requires some additional reporting because you are managing someone's finances and have access to their money and their assets and using those assets, particularly if you are, disposing of any of those assets. Like if someone owns a house and you're selling the house, you would have to get court approval to do that. And then there are, in some instances, there are like bonding requirements. We don't do a whole lot of guardianships of the estate. The typical guardianship that we're handling is guardianship of the person only. And that guardianship can also be limited in certain ways. So Stephanie, if you can go to the next slide, I think, as I said, the most common type of guardianship for individuals receiving services from Cuyahoga DD is guardianship of the person. The probate court, because it's the body that reviews guardianship applications, it grants the guardianships, and then it's considered what's called the superior guardian. So even though a guardian may be appointed, the probate court always has oversight over those guardians who are appointed by the probate court. And so if there is a question about some decision that's being made or something that's happening within the guardianship, the probate court can step in and is the ultimate decision maker with respect to all guardianships. Generally speaking, a guardian cannot be a paid provider for the individual. So you couldn't be both a paid provider and then seek to get guardianship. It would be considered a conflict of interest. The court does, in some cases, make exceptions for family members who are maybe providing shared living or HPC services to their family member and also want to become a guardian. But the probate court has to specifically approve those arrangements. Because otherwise there could be a potential conflict of interest with somebody who is charged with choosing who the provider is going to be and who would receive, payment for services, and then also being that person who's receiving payment for services. There's sort of an inherent conflict there. And so that's why the probate court oversees that. If you can go to the next slide. So, responsibilities and expectations of a guardian. A guardian has to go through sort of a training process. So they have to take this training, a course that's issued through the Supreme Court. That's a 6-hour fundamentals course. And then there's a 3-hour continuing education requirement annually. That is actually, the continuing education requirement is waived for sort of familial or non-professional guardians. So if like an attorney or APSI, for instance, would have to go through this 3-hour continuing education requirement, but that's not required of every single guardian. So that education has to be completed before the application for guardianship is filed, and that's something that has to be done first. And then the responsibilities after the person is appointed guardian over a ward is to oversee their general health and welfare. So, and this is really mostly for guardian of the person. Again, we really don't do a ton of guardianships of the estate, but guardianship of the person, one of the main requirements of a guardian is that they basically make decisions that are in the best interest of the individual. These decisions could be related to medical care. They could be related to transportation. You could choose housing, personal care. It could be really just about anything that is related to the everyday life of an individual. the responsibility is intent of a guardian, and the expectation of a guardian is that they are making these decisions both in the best interest of the ward, and also with the ward's kind of preferences in mind. I mean, the idea is that just because you're given the responsibility of making decisions for somebody, it doesn't mean that the individual has no say in those decisions, or that you can just choose whatever you want without regard to how it would impact the individual. There's a concept of like a least restrictive environment. And so that idea is that the desires and wants of the individual are first and foremost, and that those wants and desires are being restricted in the least possible way while still ensuring that they are healthy and safe. And so that's kind of what the expectation of a guardian is. So you're not, just because you're a guardian doesn't mean you are like an overlord and can just make every decision that you want. You have to still take into consideration the desires of the individual who's your ward. Next slide. So the process for becoming a guardian, essentially you fill out, there's an application form that's available on the probate court's website. We can always get that for you if it's easier to request it through us. We're happy to provide a blank copy of that. The proposed guardian would fill out that application, and then it lists what's your relationship to the ward, and what is the disability or impairment that's leading them to need a guardian in your view. There's a whole lot of questions, and so you fill that out, and then there's an affidavit that has just kind of recently been added. That affidavit basically explains any past criminal charges that you may have had. That actually needs to be notarized. So that's just something to keep in mind. We have notaries at the board. If that's something that you would need, we'd be happy to notarize that for you. And there's no charge for that either. And so you fill out the application and the affidavit, and then those documents get submitted to the probate court with a filing fee, which is $175. For Cuyahoga DD volunteer guardians, the fee is waived, but that wouldn't apply for like family members of individuals. Those wouldn't be considered volunteer guardians through our volunteer guardianship program. And then along with that application, you're expected to also submit the expert evaluation that Dr. Cirillo talked about earlier. So that is something that you can get from us, from our behavioral health department, as he talked about. And so that evaluation has to be submitted with the initial application for the application to be considered complete and get processed by the probate court. So then once that's filed, the probate court assigns a court investigator. That person goes out and meets with both the proposed ward, so the individual for whom guardianship is being sought, and then any next of kin. So say that we had a volunteer guardian. So the next of kin could, in some events, be the applicant. And the investigator, I believe, also reaches out to the applicant to kind of find out where they're coming from and why they're applying for guardianship. But this is sort of a safety mechanism to ensure that people are not applying for guardianship over individuals without anyone knowing that they're doing it, or without them having a personal relationship with the individual, or that they're coming through, the board's volunteer guardian program or anything like that. So the court wants to ensure that people aren't applying for guardianship over people that they don't even know or have any interaction, and also to ensure that the person who's applying for guardianship is the most appropriate person for that job. Because in some events, you could even have a family member who's applying, and maybe there's a different family member who might be a better fit to be guardian. And so they just want to make sure that they're reaching out and kind of getting the full picture of what's happening. So after that, the investigator issues a report to the probate court judge or magistrate, and then the probate court will schedule a hearing to go over those findings, to hear from the prospective ward and the guardian, and then they will make a decision at that point about whether or not guardianship is appropriate for the individual. The hearings right now have still been over Zoom because of the COVID pandemic. I don't believe that they've returned to in-person hearings, although I do believe that you can request an in-person hearing. So if you would prefer to go into the probate court, it's not prohibited. It's just, I think in the interest of expediency and everything, they've just sort of kept those hearings on Zoom for the time being. And those hearings, I mean, they can be anywhere from, a couple minutes if it's a pretty clear case, to a much longer hearing where the court takes evidence to make sure, because a ward could contest their guardianship. They could say that they don't want to have a guardian, and then the court would have to hear those objections of the individual to them, or you could have competing guardianship applications. Like I said, if you have more than one family member and multiple people are applying for guardianship, then the court, that would lead to a longer hearing where the court would hear evidence, and ultimately the court makes the decision about who is the most appropriate person, if any, to serve as guardian. If they find that someone should be guardian, they issue what's called letters of guardianship. And that's a formal document that comes from the court. It's signed by a judge, and it says, that you have guardianship over this person. It lists any limitations on that guardianship. If there's a time limit, there could be a time limitation. So you could have somebody who is appointed as a temporary guardian for just a specific period of time. It could be limited to certain decisions. So there could be a limitation on maybe medical decision-making or something like that. So those would all be listed in the letters of guardianship. And that's the document that you would need to hold on to and provide to prove that you have decision-making abilities over somebody. So for instance, if someone were to go to a doctor and needed you to make a decision for them, you would provide the letters of guardianship to show that you have the decision. So it doesn't, the court's involvement does not end the letters of guardianship. Dr. Searle kind of alluded to this before, that guardians have. And so it's because the court wants to continue to make sure that the person who has been appointed as the guardian continues to be the most appropriate person to serve as guardian, and also to ensure that, they continue to have oversight over what's going on. And so, that the person who's serving as guardian continues to be involved with the ward and not just, not speaking with them or meeting with them. So every 2 years, the guardian has to file what's called a guardian's report. There is again a form that's available on the probate court's website. Technically, the guardians are also supposed to file an annual plan every year, but the court doesn't really require that, except in the case of these professional kind of guardians, like an attorney or AFC. Both of the forms are available on the probate court website, and the court will accept an annual plan from anyone. So if you want to file one, but it's not a reason that I've seen that they would remove a guardian if it doesn't get filed. But the guardian's report is very important and must be filed every 2 years. The court will send out a reminder. So they will send in a notice by US mail 30 days before the 30 days before the guardian's report is due, and then it's expected to be filed within 30 days of that notice. They will grant, extensions of that, but failure to file the guardian's report can be grounds for removing a guardian. Along with the guardian's report, you have to include another expert evaluation, essentially saying, that listing the reasons why the person continues to need a guardian. This is a requirement that can be waived by the court, but it has to be formally waived by the court. So essentially, along with when the first guardian's report is made, there's a section on the expert evaluation form that requests the court to dispense with future expert evaluations, because it's not expected that the person's condition will change over time. And that serves as like a motion to the court that then the court can grant, saying it's no longer going to require you to submit an expert evaluation every single time you submit your guardian's report. But you cannot leave out the expert evaluation unless the court has formally ruled that you don't have to file it. And then, like I said, failure to file the guardian's report can result in removal of the guardian. They'll usually give you like a second notice. And then after that second notice, if you still fail to file it, the court can terminate the guardianship or remove the guardian. So there are alternatives to guardianship. Guardianship is a pretty serious step to take, because you're formally going through court proceedings to take away someone's right to make decisions for themselves. There are sort of these less restrictive measures that can be taken that can be options for people who maybe want to retain some of their decision-making capabilities. So one of these is a power of attorney. This is a voluntary document that gets signed by an individual. They would appoint someone as their power of attorney. There are a couple of different kinds of power of attorney. So there's a financial power of attorney in which somebody would be appointing someone to assist them with financial decisions. There's a healthcare power of attorney where someone might appoint someone to help assist with healthcare decisions. You could also just have like a general power of attorney if there's a specific matter that you want somebody to have authority to help you with. I mean, a power of attorney could kind of be tailored to what the person wants, but it is voluntary. So the individual who's granting the power of attorney kind of gets to decide what the scope of that power of attorney is. Because this doesn't require approval of the probate court, it can be revoked at any time by the individual. So the individual could say, I want to have you help me with making financial decisions, and they can sign a financial power of attorney, which would grant someone the right to make financial decisions for them. But if in the future they decide they don't want to continue having you make those decisions for them, they could say, I revoke this and it's not in effect anymore. And then you would not be allowed to make financial decisions for that person anymore. And none of that requires any involvement from the court. So it's sort of a less formal thing to do. A chosen representative is very similar to this. It's a voluntary appointment. This is sort of a concept that comes out of the developmental disability community and the Department of Developmental Disabilities. So this is a voluntary appointment of an individual to assist with decisions related to DD services. So this is kind of specific to choosing maybe a provider or certain services that you might want. Again, this is voluntary, so it can be revoked at any time and there's no formal court involvement. A payee is a separate matter that is somebody who manages finances for someone. So this can be, a payee can be appointed in a couple of different ways. A payee can come through the Social Security Administration. So if the Social Security Administration determines that somebody can't manage their finances for one reason or another, they can appoint what's called a representative payee, and then those benefits would run through that representative payee, who would be responsible for paying somebody's bills with their benefits. There's also, even just a general payee. So a person can ask to have a pay or agree to have a payee appointed, in which case their income and their benefits would go to the payee, who would then make sure that all of the person's needs are being met financially. So like their rent is being paid, their utilities are being paid, they have food, that sort of thing. And then there might be a certain amount of money that's allotted to somebody for, spending money for whatever they want. So there's a couple of different ways that you can have a payee appointed. A guardian, actually, even if they're not the guardian of a state, can agree to have a payee appointed, but it would be a separate payee. They couldn't appoint themselves as the payee. And then a limited guardianship, I talked about a little bit. This is just a guardianship, but it could be limited in some way, like by time or scope. Again, if you just wanted somebody to make medical decisions for you, you could have a limited guardianship. That would still run through the court. And there's a section on the guardianship application that you check to say, if this is a limited guardianship and in what way is it limited, if the scope is limited or if the duration is limited. And so that all runs through the court. So that's just sort of an alternative to like a full guardianship of the person. You can just limit it in some way. Oh, here's some more information about pays. Sorry, I should have moved along to this. So I kind of went over this. The payee is responsible for using an individual's income and benefits to ensure bills are paid. The payee does not require probate court approval. And then I kind of just talked about limited guardianship a little bit too. And here's sort of some additional information about guardianship and how it can be limited. And even if they are not listed on the guardianship application, so if you could apply for a full guardianship of person, but the probate court could determine at the guardianship hearing that they think the person only needs help with medical decision making, for instance, or they might only need a guardian for a specific amount of time or for a specific instance. And then the probate court itself can limit the guardianship regardless of what you've applied for. They have ultimate decision making. So here's some rights that are retained. So just because an individual has a guardian doesn't mean that they have just lost all their rights and they have no, say in anything about their life anymore. Like I talked about before, I mean, they have a right to be treated with dignity. They have a right to be safe and healthy and to be in the least restrictive setting that is the closest to their wishes while still allowing them to be safe and healthy. They have a right to privacy. So the guardian, while they might have access to all of someone's medical records, isn't necessarily just allowed to go release those to everybody. They have a right to religious and spiritual freedom. So some of these are considered fundamental rights. There's rights that just don't go away because you have a guardian. The right to vote is a good example, and the right to religious freedom is a very good example. So an individual retains these rights. Just because you're guardian of somebody, you can't tell them who they have to vote for. You can't tell them what religion they have to practice. Those are things that they retain. Some medical procedures are the right to make decisions about those. So like, for instance, decision making about their reproductive rights, like the decision to have whether or not to have an abortion would be an example that the individual would retain. They, have the right to an attorney. They have the right to review things if they feel that they're not going the way that they should. They have a right to petition the court to review the guardianship. So if they feel that decisions are being made that are not in their best interest or that violate, any of these other rights, their right to dignity and respect, specifically, then they have a right to petition the court and have the court make a decision about whether or not the guardian is acting in their best interest. So these fundamental rights are very, very important, and it's important to remember that that these are, people, and they they still have rights and the ability to make decisions in their lives. So here's just some questions that we get really frequently. And so I thought it would be good to kind of address them so that people are aware of them. So the first is it possible to appoint a successor guardian to take over if the current guardian can no longer serve? So we get this question a lot because people, especially with familial relationships, people want to make sure that they have a plan that's set out. You know, if it's a parent, for instance, who is getting guardianship over their child, they might want to make sure that they know who's going to be in line behind them if they become unable to continue to be the guardian. The court does not allow you to name a successor guardian, but you can work through your support administrator or anybody else at Cuyahoga DD and let us know if there's somebody that would be preferred to serve as a successor guardian, or if there's somebody who's been identified as willing to serve. We'll be happy to note that, and in the event that the person needs a successor guardian, it just gives us a good starting point to find that guardian. The reason I think that the court doesn't allow you to name a successor is that you really don't know when the current guardian is going to be unable to serve. And so a successor guardian may not be able to serve at the time, or may not be willing to serve at the time. And so the court doesn't want to bind somebody to being a successor. But they will, you know, in the event that somebody becomes unable to continue to be the guardian, the court would certainly take the current guardian's preference into consideration in naming a successor guardian. And if somebody is deemed incompetent and their current guardian becomes unable to be the guardian for whatever reason, the court would look to have a successor guardian. So typically the court would reach out to us and say, do you know of anybody who can serve as a successor guardian? If they know that we're connected, then that's why it's good for us to know, because then we can approach and have the conversation about guardianship with whomever it is that you have identified to serve as a successor. There's just not a way to formally automatically transfer the guardianship. How is a guardianship terminated? So a guardian may resign. The court has to accept the resignation. So somebody can't just say, that's it, I'm not going to be the guardian anymore. But you have to let the court know that you're resigning. The court can also remove the person for cause or because the ward has been restored to competency. So like I talked about with the filing of the guardian reports, if somebody fails to meet their obligations as a guardian, either that filing requirement or some other requirement. So say that a ward petitioned the court and said that the guardian was not acting in their best interest, the court would have the ability to remove the person as a guardian. Or if the individual feels or someone else feels that the individual could be restored to competency, we would seek to confirm that through an expert evaluation and to let the court know that for, whatever reason, this person is no longer in need of a guardian. And so then the court would make the ultimate decision about, based on that expert evaluation, the court would make the determination as to whether or not this person continues to need a guardian. And so the court could terminate the guardianship for that reason. What do I do if I think a guardian is not acting in the best interest of the ward? So I talked about this a little bit. Anybody, so a family member, someone from Cuyahoga DD, anyone, including the ward themselves, can file a notice with the probate court to have the guardianship reviewed. There's a form that's located again on the probate court website. It's called Performance of Guardian Comments or Complaints. And once that gets filed, the court holds a hearing to review what the complaint is or the comments about the guardian and make a determination as to whether or not the guardian is acting in the best interest of the ward. If the court might order the guardian to act in a certain way. If it's not, if there's a specific concern, the court might just address that specific concern, or the court could even terminate the guardianship based on those kinds of complaints. Okay, so I think that is the end of our formal presentation. We're happy to take questions or comments from anybody who's watching. And as we showed at the beginning, we are always accepting volunteer guardians. And if anybody's interested, please contact our community development department. We would love to have more people serve as volunteer guardians because it's really a great program and it does great things for the individuals who need a volunteer.
So much, Sarah and Rick. Great presentation, a lot of good information there. So again, if you have any questions for Sarah or Rick, please put them in the chat, or you can use the raise hand feature. We'll just wait a couple minutes to see if anyone has. Oh, it looks like we do have a couple hands up. It's Lori. You want to go ahead and raise your or ask your question? You can unmute yourself and ask. And let's see, do I need to? Yeah, go ahead and unmute yourself, or Mike, if you can unmute Lori so she can ask her question.
Can you guys hear me?
Yep, we can hear you. Thanks.
Okay, yeah, I just have a question. Do you ever have a situation, I'm sure you have this, where you have divorced parents, one is a guardian, obviously, the other one wants to